November 4th, 2017. My name is Kuldip Randhawa. I have posted a number of videos on YouTube concerning the frauds that are taking place in British Columbia. I live in Surrey, BC, a province of Canada, a nation that's considered at the forefront of human rights. What I'm going to talk to you about is some of the frauds that are taking place and how other self-representing litigants can actually make certain arguments in the hopes that the legal system in BC will change. I'm going to talk about 10 issues as guidance. I'm not a lawyer. I do not give advice freely, but I feel that someone has to do the task of informing the public who are going to court, and hopefully it will help those individuals concerning certain matters that can be presented to the court, so that eventually legal authorities can be made and certain orders that can be used in the future. So what are these 10 things? The first is vexatious litigant. Under the Supreme Court rules of British Columbia, and certain other provinces have a similar rules as well, there are certain clauses that declare a person as being vexatious or frivolous, and there's another clause that deals with matters which are scandalous. So basically, if there was a CRA fraud by CRA itself, that would be a major scandal. It would involve officers of the government, and so technically speaking, the courts do not want to hear this. So this is the reason why these rules are in the Supreme Court rules. The whole purpose of having these matters is normally done, the intent was to save the court's time, so that people do not bring baseless matters to the court, so the court's time is not wasted. But instead, under abuse, what is happening is victims of fraud are being declared vexatious so that the frauds can continue and a mockery can be made of justice. So the vexatious litigant is perhaps someone who would say a blind person can see. Well, it's up to the trier of fact. Maybe that blind person is not blind, but one cannot be declared vexatious simply because of a submission that appears as being vexatious, because sometimes the evidence is manipulated, the truth is withheld. And so even in those extreme cases, a person cannot be declared vexatious. It simply isn't done. Particularly a person who's being sued by the other person. And when he's being sued, he has to have a right of defense, a counterclaim. And so how can that person who's defending a claim be declared vexatious? It just does not make sense. And I've seen this many times happen to a lot of people, including myself, in at least 3 to 4 matters now, because the fraud is continuing considerably in BC. The second matter I want to talk to you about is res judicata. Res judicata is the doctrine where a lawyer would go to court and say, this matter has been decided by the court before, and so it cannot be brought before the court again. Again, thinking of the court's time. So that only applies in a courtroom where the lawyer has not done fraud, which would be fraud before the court, and it also does not apply in a situation where the judge has accepted that fraud, which would be the fraud by the court. So these arguments should not be made by lawyers, but they're always made with the view that this is their way of dismissing the frauds taking place in the court, in which victims of fraud are then continuously victimized even further. The third matter is functus officio. It's a function of some organization, some agency, or some officer in a department. Could be the Department of Justice, for example. Could be a CRA officer doing an assessment of taxes. That agency has a mandate to follow rules, regulations, and be subject to an appeal. If that person is doing crimes, that person should be investigated by the RCMP. And so the intent normally is that an agency has fulfilled its function when actually it has not, under those circumstances where fraud is openly done by a number of people. So the courts itself cannot conclude these matters based on functus officio, and lawyers cannot make these submissions to court when they know that they're actually involved in the fraud. The fourth one is respondent superior. Respondent superior is a person who starts the action. He's a person that retains counsel and says, I want to sue the other person because of whatever the claims may be. But that person is responsible for commencing the claim. If that person is involved in fraudulent claims, that person is going to be held accountable. But what often happens is this. The lawyers, because they know how to manipulate the system to such a level that their clients are also misled. The matter is delayed. Improper advice is given. And so they have connections. They have abilities to go to court because they know certain judges. And so they manipulate the culture of that person. It's happening to a lot of people from the ethnic community. It's happening to a lot of Sikhs because they have politicians who do not want to speak out. They're simply elected for the ethnic vote. So then the lawyer is the respondent superior. And when the lawyer is presenting fraudulent information, then it's not the person who started the action that's responsible, even though that person will take some blame. It depends on the circumstances of each case. But certainly, the officer of the court, who's duty bound to tell the truth, is going to be held responsible at a higher level. The fifth thing is bad faith. Bad faith is like you go to court, you know that someone's committed a crime, but you then blame it on the other person. And so you know there's fraud taking place. The person goes to court saying, I'm representing Mr. X, I want to get him justice. But actually he's getting injustice done to the other person. Sometimes the safety of the public is compromised. Sometimes the person who's high up the ladder has to be protected. Maybe some minister. So essentially speaking, bad faith is not doing something lawful. That is not the intent of the acts. That is not the intent of the courts. And so bad faith is basically simply bad faith. Something which should not be happening at all. And lawyers are aware of that. Typical example would be insurance company denying a claim over some meaningless arguments made by lawyers, which the judge then simply accepts, and then the insurance company doesn't have to pay the money. Next one, 6, is absolute privilege. Absolute privilege is a wonderful doctrine. It gives the rights to all litigants, including lawyers, to tell the truth without the fear of telling it. You go to court on the basis that you should not feel under duress. You should not have any fear whatsoever, and the judge has a duty to listen to the truth, and if that truth is withheld because the person fears telling the truth, then that justice cannot be done. But sometimes what happens is the truth is actually going to be revealed, may actually end in the case being dismissed. But then it comes down to morals. Then it comes down to the trier of facts, because the trier of facts has to decide on the merits. And so absolute privilege is not a doctrine where lawyers can commit fraud openly. It's a doctrine so that you have the freedom to tell the truth before a trier of judge. It is not a doctrine which allows a person to do fraud. 7 is access to justice. Simplest way to understand this is a person goes to court, but he can't get in because the door's closed. Well, that's never happened to me in Vancouver, where the doors are closed, unless of course it's a weekend. The doors are always open. You can walk in and have access. But there are ways in which access is not given to a person seeking justice. When a person at the counter does not accept your application because he's been told not to. So it's rejected over some trivial matter, some date that's missing, which could be handwritten, or something else that the person has been told, just delay this application. So now person has to go back and come back the next day. And so the application is refused, and so access to justice is denied and delayed. And then you go before a judge. The judge is actually biased. He's been told not to give justice. And so access, a person goes to court, he pays for the application, he makes the application, submits it, and all that is done. But everything is heard before a judge who doesn't want to give justice. So that is the worst thing that can happen. The one is the lower level is at the when you're actually filing and the person doesn't accept it, and the highest level is going before a judge who's got no intention of giving you justice. 8 is the sanctity of the court. The sanctity of the court is based upon faith, on religion. It's based on statues that are proudly put up in the court to signify that this is a place where justice will be done. One is not supposed to raise one's voice. I understand that. But at the same time, just because you don't raise your voice and you're committing a crime, the sanctity of the court is not protected then. There is no sanctity of the court when a lawyer tells lies in the court. There's no point having statues, no point putting up pictures of justices on the walls. Because when a justice does bad activity, bad faith, or commits a crime, the sanctity of the court means that person's picture should not be put up on the wall. That is not what it's all about. Everything that belongs inside that building, which is a courthouse, has to be pure, has to be done with conviction. One has to have faith. And when you have no faith, then basically there is no sanctity. Then you can expect people to raise their voices. And then you can expect perhaps 10 guys walking in, or perhaps the police coming in. I recall the Chief Justice issuing an order when some police had actually walked into the court, and they said they should not have done that because it's the sanctity of the court is being compromised. Well, is it not being compromised when people are being attacked in the court? When sheriffs are pushing people who are cooperating and leaving the building because they decided that they just don't want to be in this place where crimes are taking place, and the person is being provoked? Is that sanctity of the court? Where a judge is doing fraud and commits a felony, arrest a person because he's telling the truth or calling 911, is that the sanctity of the court? I think not. 9 is the jurisdiction. When the people within the court system are not behaving as they should, they're breaking the law, they're interfering with the person's livelihood, they're gridlocking a person into the court so they can make money. Fees are paid to the government. Applications are made and they're refused, or they're not heard. Or an application is made and then an order is made in that hearing when the person is put in jail, which is kind of what happened to me on June 8th, 2017, before Justice Murray. Is that justice? You don't want to listen to the truth, you want to listen to the lies? Is that what the jurisdiction of the courts are? To listen to lies? If that is the case, forget the rule of law and forget all this thing about come and tell the truth. Why don't you just say, come and tell us lies? Because that is what is happening. There is no jurisdiction when a judge is involved in that crime and has committed a felony. That judge has to be impeached. Eventually, 10, which can sum up everything that's happening in my life, is collateral attack. Generally speaking, is a legal term where one person tries to get a alternative judgment in a different courtroom to the one that was actually held before by another person. So it could be a divorce proceeding, so the person goes to another court to undo the divorce in another jurisdiction. That is termed as a collateral attack. But there are other collateral attacks taking place, which I never talked about. This is where a lawyer goes before a certain judge, a judge who he knows is biased, where he knows he's going to get a favorable decision. that is a collateral attack on the person who is seeking justice, because justice is going to be denied. This is where someone in the registry will say, oh, this matter is going before a judge and she's only going to be deciding what's going to happen. She's going to wrap up everything up. Well, how does one wrap up something that hasn't even been heard? If everything is pre-decided, then that is a collateral attack. When a person is filing fees for the application, driving all the way to Vancouver to make sure that the times are met according to the Supreme Court rules, he does all that running around, and then he comes to court, and then he's told to sit down. That is a collateral attack. I think I've said enough for the 10 points that I've made. I hope that other self-represented litigants will want to contact me, should they wish to do so. My email is kuldiprandhawa5@gmail.com. That's KULDIPRANDHAWA5@gmail.com. God bless.